I'm just going to slide around so I can come and step into here to speak with the Jane Sullivan.
All right.
Don't cough, sneeze.
Is the other lady speaking
So Jane.
All right.
Thank you. Please be seated. Good morning. We're in session in the matter of State of South Dakota versus Jason Ravnsborg. This is time that had been set for a trial to the court in this matter. A couple of housekeeping measures I want to address. This case is being heard in Stanley County rather than Hyde County, which would have been the venue for the action. This was moved here at the request of the court and with consent from the parties, primarily for the convenience of the court and the parties and to accommodate to what we understood would be large crowds, which the Hyde County Courthouse isn't well equipped to handle. The case, there's a couple of matters that I want to address before we begin. This case was, as I said, to be a trial to the court rather than a jury trial. That was the court's decision by withholding any likelihood of a jail sentence being imposed. Jury trial is not guaranteed in that instance. I don't think a jail sentence in the context of this case would have had any particular disciplinary benefits for the defendant, and so it was my decision not to hold a jury trial. Also, there had been a motion previously for disclosure of certain medical evidence to support a potential defense in this case. I granted an in-camera review and did review such records, and that's certainly the right of the defendant to seek such information. However, having reviewed the records, I found nothing to be relevant to the potential defense, and I am filing an order with the clerk at this time denying access to such records. Mr. Ravnsborg is not present. He is appearing here through Mr. Wrench by power of attorney, and a power of attorney has been filed on his behalf. We are now at a point where we are proceeding to a change of plea in this case. And I understand that there has been a plea agreement reached in this matter. Mr. Wrench.
That is correct, Your Honor. May I set it on the record?
Go ahead.
All right. We've reached a deal wherein my client is going to enter no contest pleas to count 1, which is operating a motor vehicle while using a mobile electronic device, east of Highmore, which is on the opposite side of Highmore than the scene of the accident, and no contest to count 2, lane driving. The state will remain silent as to the defendant's request for a suspended imposition of sentence.
And is that correct, State?
Yes, Your Honor.
Is there anything else in that plea agreement that you understood to be part of it?
No, Your Honor. The parties are otherwise open to speak with respect to the sentencing.
All right, then, as to count one, in honor about the 12th of September of 2020 in Hyde County, Jason Ravnsborg is charged with the offense of operating a motor vehicle while using a mobile electronic device east of Highmore city limits. To that plea, or to that charge, what is his plea?
No contest.
Count two charges that on that same date in Hyde County that the defendant did while driving a motor vehicle on a roadway divided into lanes, failed to drive said vehicle as nearly as practicable entirely within a single lane, and did move from such lane without first ascertaining that such movement could be made with safety. What is his plea?
No contest.
And the state is filing a dismissal then of the third charge?
Yes, Your Honor, we will do that at the conclusion of proceedings today.
I mentioned the power of attorney that has been filed with the court. Through that power of attorney, Mr. Ravnsborg has agreed that his counsel may enter a plea on his behalf of no contest. He's indicated that he is given this freely, voluntarily, and without coercion, and without not the result of any threat or promise other than what is stated in the plea agreement that has been put on the record. He also indicates that he understands that pleading no contest waives his right to confront and cross-examine witnesses, right to a jury trial, right to have the state prove its case beyond a reasonable doubt, right to remain silent, right to subpoena witnesses on his behalf, and right to the assistance of an attorney at trial. Having pled no contest to the charges, the court need not make a factual finding in this case and may proceed to sentencing in this matter. The court, although I had understood there was going to be a request for a suspended imposition of sentence, I'll withhold my finding at this time pending sentencing arguments. So with that, state.
Thank you, Your Honor. The facts underlying this case, as the court is well aware, result from the North Dakota Bureau of Criminal Investigation and the South Dakota Highway Patrol providing that on or about September 12th of this year, Ravnsborg was traveling east of Highmore city limits within Hyde County, and he was determined through the investigative agency's reports to be using his cellular device. They had GPS coordinates, studies, reconstructions conducted to prove that he was reading through political blogs, web pages, weather apps, those types of things while driving. With respect to count two, there was a plethora of investigative materials and trend line information and forensic mapping showing that Ravnsborg was clearly outside of his lane of traffic at the time that he had impact with the pedestrian, Mr. Joe Boever, with his vehicle. The facts have been everywhere. This case has been very publicly played out. There's been political underpinnings. There has been more information spilled out in this case, I would say probably than any other case I have witnessed in my 20 years of practicing law. For the family of Joe Boever, my condolences sincerely go to them. I know that the recompense they seek cannot be given in this court today. These are misdemeanor charges. We're not going to undo the past. We can't redo the past. I know they're frustrated with the process, and to all of them, I am very sorry for the loss that they have endured. I'm very humbled by the conversations that I have had with them, and I'm mindful of their positions as I stand here today before this court. With respect to the sentence imposed by the court, I understand the court's position with respect to jail time, but there's a lot of wonderful information in the letters that have come forward from the family suggesting educational endeavors and ventures for the defendant to go forward and to help educate young drivers that I think really sat well with me as I read through them. I would ask the court to seriously consider those. He's in a wonderful position to be able to do some of that education, and I think that that would be very appropriate for the court to consider in this case. Albeit misdemeanor charges, the worst possible and harshest possible result occurred, and we are dealing with what has been a horrific year for a lot of people. I would expect that the family does not consider an imposition of the maximum amount of jail, even if suspended, maximum fines. That's simply not going to give them what they want. There's been some specific requests from the family towards things like the funeral costs that mother has paid towards restitution. We would ask the defendant be responsible for those funeral costs. It's minimal in comparison to the emotional loss that she has endured, but it is a financial detriment to her. And so we ask the court to consider that request that has been made in writing to the court. There are also the Hyde County restitution costs that have been set forward of the $3,742.38. Court costs, of course, that are required by law of the $78.50. And with respect to any other position of this court on suspended imposition of sentence or anything else, I think this court has more than enough information to make that decision. That is a decision for the court and the court only, and I don't think you could have been given more information in any other case to help you with that. The background of the defendant, his actions, the family's positions, the public's positions, you've heard them all. I'm not going to reiterate them over and over. There are some specific requests from the family to be able to speak to you directly, and I would ask that you reserve this time to hear from them. The family representative for the blood relatives, the siblings and mother, will have a statement by Jane Beaver, and I will ask that they come forward so the court is able to hear them. There's also a request from the spouse, Jennifer Beaver, to be able to speak separately, and if the court is inclined, I would call them forward at this time.
Okay. Ms. Jane Beaver, do you wish to make a statement? Yes, please come forward.
Hi, my name is Jane Beaver, and I'm Joe's sister. Your Honor, thank you for allowing me to speak on behalf of my mother and my siblings today. We have waited 349 long days for this case to come to an end, and this is not the end we hoped for or expected. Joe, our brother and son, died horrifically and was left behind carelessly not once but twice. The first night he was killed, the second after the defendant returned to the scene the next day. Our brother laid in the ditch for almost 12 hours. This is inexcusable. If an ordinary person had committed these crimes, we believe the case would have been closed months ago. Instead, State Attorney General Jason Ravnsborg ran our brother down and then used his position, knowledge, and resources to selfishly string this case along and, more importantly, widen and deepen the wounds of our loss. We feel that at no point has the defendant shown any remorse and has instead demonstrated callousness with respect to the life he took and the victim's family and friends. He has demonstrated arrogance towards the law he, as an attorney general, is supposed to uphold. He has betrayed the morals and values he possesses to stand for. Honor, humility, and courage, these words will never be used to describe the defendant. Why, after having to wait nearly a year, do we not have the chance to face him? We were told that he claimed threats were made against him, but all this time, he's carried on his duties as AG, traveled to a conference in Hawaii, testified in Washington, D.C., and given speeches across the state. Yet he was allowed not to appear today. His cowardly behavior leaves us frustrated and makes moving on even more difficult. Your Honor, we do not feel a couple of fines is adequate punishment for killing a man. In our victim impact statements, we included ideas for creative sentencing, including making public service announcements and speeches on the consequences of distracted driving. Thank you for your consideration, and thank you for this opportunity to speak to you.
Thank you, Ms. Beaver. Jennifer Beaver, present.
Judge. I'm Jennifer Boever, wife of the deceased Joseph. Since the loss of my husband, Joseph, my life has become incomprehensible. I lost the love of my life, my best friend, and my chance for happiness. He was a husband, a son, a brother, a stepfather, a grandfather. Joseph was a highly intelligent man, teaching me many things in life. And Joseph was a very private and quiet man, but he was a very caring man, which led him into nursing to help people. His patience and many people cared and loved him. People remember Joseph for his quiet demeanor and for his compassion. Jason's actions on the night of September 12th changed many lives. It changed my life, my family's lives, my children's lives, my grandchildren's lives forever. His actions are incomprehensible, inexcusable, and cannot be forgiven. I have had to endure many things since Joe's death, stating that the fact that I was at work the day he was discovered. A friend mentioned that he thought it might be Joseph since his vehicle was further up the way. I had to endure a night of working, of being able to watch the events unfold from our workplace window, wondering if it was my husband, and then endured the fact that I was not informed of my husband's death by the officials until Monday morning. I feel I was not given the respect of a wife to be notified that her husband had been killed in a horrible event. I had to call a relative after work on September 13th to confirm that Joseph was deceased. I broke down completely after that phone call. I did not get to say goodbye to my husband. He has taken away my will to live, my belief in hope, faith, and happiness. I have been devastated, depressed, and have been seeking counseling to try to cope with the anxiety levels rising, my coping skills decreasing, and my PTSD. I've had to start medications to control feelings of rage, anger, and hopelessness, and to help me sleep and stop having nightmares. I dread waking up every morning and going to sleep every night because I know I must face this nightmare every day for the rest of my life. My husband was clearly abiding by the laws and was not where you claimed he was. Jason's intentions of trying to put the blame of his injustice to his family and his memory. I do not have much left of Joseph except for memories and some photos and flashes of how my life used to be before you took him away from us. We were building our lives together, and now we will never have that again. Since I must live with this every day for the rest of my life, I hope Jason does too. I passionately believe that he knows what he did and failed at his position as official. This was not an unfortunate accident. This was a reckless action on his part. He's taken away everything from me and my family. I love Joseph with all my heart and wanted us to be together forever. I was proud of my husband and certainly will miss him forever miss his love for me. I will never get the feeling of loving hugs, his enthusiasm of things he loved and shared, especially his passion for growing jade plants, his loving of reading and quoting Nietzsche to me. Joseph fought long and hard through his life and had his share of struggles. But he had started a new life in Highmore and put down roots here with me. And I am now at a loss to how to think, how to act, how to react, how to go on with life, and how to cope. I am constantly stressed, fatigued, angered, and hopeless. I'm financially burdened with medical bills for Joseph and bills for the house and repairs. I've had to leave work a couple times because of my emotional state from constantly being bombarded by media coverage that has shaken me to my very core. I was attending college online at the time of Joseph's death at Colorado Technical University for the criminal justice, majoring in forensics. I cannot handle continue to go to school, work, and deal with the death of my husband at the same time, mentally or emotionally, so I had to drop out of college. I have no desire to do anything or deal with anyone because the people do not know how to react to me since this is such a high-profile case. I do not like to deal with people anymore because I just want to discuss the situation that he has created. I'd also like to say, Judge, I'm not one that believes in, I agree with you, yes, there should be public announcements and things like that. But I disagree, I'm sorry, sir, with the fact that he should not do jail time for his actions. If it was any normal person that did this, we would have already been in jail. We would have spent our time in jail. What he did is he broke his own law. His law states, do not use your phone. And what did he do? He was using his phone and he ended up killing my husband that night. And it has taken an emotional toll beyond anything I've ever seen. So I'm against the fact that he will not get jail time at all.
I understand that, ma'am. Thank you.
Thank you.
Anything further from the
Nothing
state?
further from the state, Your Honor. Thank you.
Mr. Wrench?
May I speak seated so I have my notes spread out?
You may,
here?
go ahead.
Thank you very much, Your Honor. I'll just use the words of the prosecution when this case was brought. This is not a homicide case, and it's not a manslaughter case. The evidence did not support felony charges of vehicular homicide or manslaughter. At best, negligence, which is insufficient for homicide. They even carried that same position into the last hearing we had when it was explained this isn't a homicide case. And you know it isn't, and that's what is the mix-up here with the family. They think it's a homicide case. You know, the simple fact of the matter is accidents happen, people die, it should not happen, nobody wants anybody to die. Jason Ravnsborg didn't want this fella to die. Nobody wants any family to suffer the loss of someone they love. And nobody blames a family for disliking greatly the person who is involved. And in this circumstance, he should not be treated or sentenced like somebody who's facing that type of a charge. He has lived a good life. He is an honorable man. He is not a coward. He has a Bronze Star defending our country. What happened out there that night could have happened to anybody. Anybody who's gone across rumble strips knows that it happens. Now, the statement was just said by Mrs. Boever that he broke his own law while using the phone and that caused this accident. It is conclusively proven that that phone was not in use at the time of this collision. That phone, you can tell the exact second everything happened. You can tell coordinates and everything. And the phone was not being used from east of Highmore all the way through. This was an accident. She said that he was reckless. Well, guess what? Reckless has a defined meaning under our law. And if a person's reckless and causes the death of another, that is a homicide case, second-degree manslaughter. Those facts were not here. The first-degree manslaughter case requires that vehicular homicide requires that someone would be under the influence of alcohol or drugs. Nothing like that was here. There were witnesses all over the place where the Attorney General was earlier that evening, and not one person saw him take a sip. He generally does not drink. That's why these charges are not homicide charges. That's why we're not here today to deal with attempting to make right the death of Mr. Boever. We're here today to deal with 2 misdemeanor traffic infractions, the lowest level of offense we have in this state, a Class 2 misdemeanor. So I've been through many sentencings on homicides, and they're like this, where everybody stands up and talks about how they want to be paid back for the death of the person, how they want the funeral expenses, how the state would want autopsy costs, all those different things. And I'm here to say, nobody wanted Joe to die, but that's not the issue here. It can't be made right today. That's for another day and another venue and a civil action for a wrongful death matter by Mrs. Beaver, which she intends to file. So that doesn't have anything to do with the court's sentencing today. What's before the court are these misdemeanors. You have a person who qualifies for a suspended imposition of sentence. Just because he's the Attorney General doesn't mean that accidents can't happen. Just because he's the Attorney General and is involved here does not mean that the fix is in and there's some great conspiracy not to hold him accountable. I would submit to the court that any person in this state, from the highest to the lowest, if they would have been involved in something like this, with no alcohol in their system, no drugs, called 911 immediately, 18 seconds after the collision, met with the sheriff, talks with the sheriff, and then is allowed to go home and is even allowed to use the sheriff's car the way small town people will allow that to happen. Any person in those circumstances would not be looked upon as a coward, because a person who calls in 911 right away doesn't have anything to hide. They call in so that they can get help. And this contention that he had to have known that it was Mr. Beaver, that's just completely false. It's completely false. If you calculate the speed of a vehicle and how much it can travel, in the blink of an eye, a car can go 100 feet in a blink of an eye. In a blink of an eye. My client has been consistent from the beginning that he did not see Mr. Beaver. And nobody else who came to the scene that night did either. Everybody talks in this case about a flashlight, seeing a flashlight out in the grass. The tow truck driver didn't notice Mr. Beaver. The sheriff didn't notice Mr. Beaver. My client didn't notice Mr. Beaver. Nobody driving by noticed anything. And the next day, my client sees debris on the roadway and goes to kick it off of the roadway and sees this and immediately summons the police. My client was no coward. He did not walk away and leave someone unattended for any malicious or bad purpose. In fact, what were his actions afterwards? He goes in and he speaks to the North Dakota folks, gives them statements. He basically opens up and says, anything you want, hands over the phones, everything. This is not a man who had something to hide. He's a lawyer. And every lawyer in the world knows that if you're accused of a crime, you clam up and you shut up. But he didn't do that. He marched right in and he told them the way he thought it happened. This is hardly a guy who's trying to use his connections to improve his situation. He did that legally to his detriment because he has honor about him. Why is he not here today? Because people in our state have a right to have a lawyer appear for them on misdemeanors when it could be all something that they do not want to go through. That's his right. You have it, I have it, every person in this courtroom has it, every person in this state has it. If the highest law enforcement officer in the state can't take the benefit of the same rights that we all have, then who can? He has acted with honor in this case. And what has happened to him in this case with these political attacks is not honorable. And it has taken the focus completely away from the entire situation at hand. So what I'm asking the court to do is I'm asking the court to give him a suspended imposition on each count for 30 days, make him pay a fine and the court costs required by law, and give him a suspended imposition because he qualifies and society benefits about it. If the court wants to stretch that out beyond the 30-day maximum sentence, as is often done on these class 2s, 6 months or whatever, then we don't want to suspend him. We just want the sentence, the 30 days on each, and go from there. I would also remind the court that the law is that if a person loses a jury trial, they can't face jail time, and that means suspended jail time too. Any jail time is not allowed, even suspended jail time. Now, I want to talk about restitution in this case. There are restitution requests, and they consist of funeral expenses by the mother. And we've also heard the state's attorney mentioned restitution to the county, although I think that might be a misnomer. I think probably they mean costs in that regard. As it relates to restitution in this case, under our statute defining restitution and what it is for, the court does not have the authority to grant restitution, and I will tell you why. 23A 28-1 says, "It is the policy of this state that restitution shall be made by each violator of the criminal laws to the victims of the violator's criminal activities." Criminal activities. The very next statute defines what criminal activities are. And when you have a definition within a code section, that applies to the statutes in that code section. And guess what 23A 28-2 sub 2 says? It defines criminal activities as follows. Quote, "Criminal activities," close quote, "includes any crime for which there is a plea of guilty or a verdict of guilty upon which a judgment of conviction may be rendered." Listen to that again. Any crime for which there is a plea of guilty or a verdict of guilty. We don't have a plea of guilty in this case. We have a plea of no contest. We don't have a verdict of guilty. A verdict is a decision rendered by a jury or a court after listening to the facts. It's not accepting a plea. Based upon 23A 28-1 and 2, the court does not have the authority to grant the restitution requested. Furthermore, there is a request for funeral expenses. The request is made by Mr. Boever's mother. First of all, I understand that that was insurance money that paid that. Now, I don't know that for sure, so I will tell the court I don't know that for sure. But if you look at 23A-28-2, restitution includes pecuniary damages, subsection 3. Pecuniary damages, all damages which a victim could recover against the defendant in a civil action arising out of the same facts. The only civil action available is a wrongful death matter. We know that Mr. Boever's wife is the one who's going to file that, and we know that she is the person who has standing to do that. Under SDCL 21-5-5, a wrongful death action can only be brought for the exclusive benefit of the spouse or the children, and if those don't exist, then the parents. By virtue of the fact that Mr. Boever is married, the mother has no standing to claim pecuniary damages because she could not recover any in a civil action. And what is restitution defined as under subsection 4 of that statute? Full or partial payment of pecuniary damages to a victim. So these damages under the law of restitution do not flow from criminal activities because it's a nolo contendere plea. You may ask why that would be. Well, because a nolo contendere plea keeps the matter out of a civil courtroom so that a separate jury under a separate action on a separate day can make the true measure of damages, which is the way that it is supposed to work. And that statute, SDCL 23A-28-2, is unambiguous. Now I want to move to the issue of court costs. First of all, if the state really is taking the position that these things are restitution, it's clear law in South Dakota that a county is not a victim for the purposes of restitution when a case is prosecuted and the county is not literally the victim in the sense that someone damaged county property or something like that. So let's talk about what costs they ask for. They ask for overtime costs of employees for doing their job. However, SDCL 23A-27-26 states costs shall not include items of government expense, such as jurors' fees, bailiffs' fees, salaries and expenses, of special agents, reporters per diem. And then 23A-27-27 lists specifically the costs that can be allowed. Witness fees and mileage paid or ordered paid, including the fees of witnesses. Costs of transcripts, court-appointed counsel fees, filing fees, breathalyzer blood test fees, and other chemical fees may be included in the judgment for costs. These requests for example, the fees of the coroner, for example, the overtime of the highway folks that blocked off the highway as the investigation occurred, all of those things, those are salaries. Those are paid through the employment process. Everybody pays taxes. The money goes into the pool, and the public employees are paid. That's part of their job. That's something that is not authorized by costs. Here also, there's a request for the autopsy fee and the matters related to the autopsy and the travel to the autopsy and all that kind of stuff by the funeral home, the autopsy occurring over in Minnesota. And I want to read 23A-27-26 and talk about that. Judgment against defendant for costs, items excluded, enforcement is civil judgment. And the body of the statute starts off, quote, in all criminal actions, comma, upon conviction of the defendant, comma, the court may adjudge that the defendant pay the whole or any part of the costs of that particular prosecution. It says particular prosecution. What particular prosecution are we on here? We're not on the prosecution of a homicide. Just because that's investigated and not brought doesn't mean that the expenses related to that have to be paid by somebody if they are convicted of a small traffic infraction. So the prosecution that we have here for a traffic infraction is different than the prosecution for a death. And it's unfair and unreasonable to attach those costs, death costs, to a traffic infraction. With all this said, Your Honor, my client didn't want this gentleman to die. This was an accident. He has acted with honor. And the people who hate him will always hate him, and they will never change their minds. And the people who love him will always love him, and they won't change their minds. And what's going on here is he should be treated like every single other person in the world. And if you would have had anybody else in this spot where people couldn't scream conspiracy, false conspiracy theories, try to claim in court, maybe it's a legitimate belief, or not a legitimate belief, a realistic belief that they have, a sincere belief that they have, that Mr. Boever was run down. People who run people down intentionally like a coyote, they get charged. This is nothing like that. This is a mere accident. Since this happened, 5 pedestrians in South Dakota have been hit and killed by motor vehicles, and charges involving the death have not been brought. And you know why that is? Accidents happen. And just because somebody dies doesn't make it a crime. So with all that said, I would ask for permission to pay the fines and legitimate court costs within the 30-day period. And I don't have anything else to say.
Salvo, rebuttal?
Your Honor,
I'm
that
particularly interested in your take on the costs and restitution elements.
Thank you, Your Honor. I am familiar with the state of the law in South Dakota. I did misspeak. It should have been labeled as cost to Hyde County on the one particular series of events. Those were not standard salaries. They were related directly to the prosecution costs. They are what they are, and I'm not going to belabor the issues of why they were there. They were legitimate costs that came in relation to the prosecution, regardless of what the charges were as we stand here today. The nolo contendere pleas, from my experiences, are standardly treated in the actual judgments as a guilty plea. With that finding of guilt in the event that happens, they are legitimate, and I will simply leave it at that.
A question on the funeral cost issue and documents I received, which I should, by the way, state that I have read all of the various submissions from the family and parties, but it's noted on there that although the mother initially paid the funeral costs, that was reimbursed by insurance. Is that correct?
Your Honor, there is a direct reference to that, and I could call forward the victim's advocate for clarification if that would appease the court.
Please.
Your Honor, receiving information from the advocates for the family, it was a general life insurance policy. It was not specific to the funeral expenses borne.
Nevertheless, the life insurance policy was paid,
Yes.
and that covered whatever costs there were involved here.
Yes.
Mr. Wrench has pointed out that this is a case about traffic violations. Unfortunately, the outcome here was tragic. It was unnecessary, and certainly not what anyone, including the defendant, would have wanted to have happened. We have in the state a bond form that is used by the clerks of court to impose fines and penalties in certain cases. And in the case of these Class 2 misdemeanors, which are, has been pointed out, have maximum penalties involved of 30 days in jail or up to $500 in fines, the bond schedule that has been developed, which anyone charged with such an offense could go into the clerk of court's office if they were cited as such. And in the case of these two statutes that are at issue, the operating a motor vehicle while using a mobile electronic device, the fine and bond schedule has a bond set at $178.50, which includes fines and costs. As to the lane driving charge, the bond schedule has a fine and cost of $132.50. Obviously, this isn't the typical case, and I don't think that anyone would expect that Mr. Ravnsborg should walk away paying $178.50 and $132.50 on the two charges. And in the context of this case, I am going to deny the request for suspended imposition of sentence, and I am going to find him guilty of the charge in count 1 of operating a motor vehicle while using a mobile electronic device, and of lane driving charges as set out in count 2. Mr. Wrench is correct that even a suspended jail time is unavailable to the court, and no jail time will be imposed in this case. I am going to impose fines of $500, and I believe the court costs on the Class 2 misdemeanor are $66.50 on each count.
$73.50.
I may not be correct on that. I didn't happen to look at that, but in any event, I will impose those court costs as well as the $500 fines on each count. In addition, as a condition of the sentence, I do find that, and perhaps it's somewhat unfortunate from Mr. Ravnsborg's point of view, that, but because of the profile, the high profile of this case, I think that the various charges that the county is requesting here are legitimate with respect to the additional costs that are imposed. I think that certainly securing the area, had it been anyone else, probably wouldn't have taken that amount of cost. And certainly the high profile of the case led to perhaps greater examination and costs involved. I'm going to grant the restitution request of $3,742.38 to the county as not as restitution but as costs. And although I understand that a monetary award to the victim's family or the victim's mother may help assuage some concerns here, I think it's also correct that there's nothing the court's going to do that's going to make anyone happy in this case. I'm going to deny the request for funeral costs. It appears those were paid by insurance and or covered by insurance, which is the purpose for which insurance was brought, and I don't think it's appropriate in the context of this case. Any other costs of restitution or award are more properly handled, as been pointed out, through a wrongful death action, which I understand is being contemplated currently. Mr. Ravnsborg will have 30 days within which to pay any fines and costs. In addition, I am going to require that Mr. Ravnsborg do a significant public service event over a period of 5 years, once each year, on or about the anniversary date of Mr. Beaver's death.
I have a question, Your Honor.
Yes.
If the maximum penalty is only 30 days on each count, how can you go out 5 years?
I think that case law has supported that that in fact probation periods can extend beyond the possible jail time, and I'm basing it on that.
That's only in the case of a suspended execution of sentence or a suspended imposition of sentence, and this is neither. And I appealed a case on that here maybe 2 years ago. That's why I have it fresh in my mind.
Well, you submit me the case on that. We'll withhold the entry of the judgment. State will prepare the judgment in this case based on what I've said. You can have your supporting information to me by the first part of next week.
I can sure do that. If you give me a second, I might be able to find it here. I thought I had something in here, but of course, the moment I'm trying to, I'll just get it to you by the first part of next week.
Get to the state, so I'll have an opportunity to respond as well. I'll take written responses on that, and we'll have no further hearings.
Thank you, Your Honor. Oh, and one other thing, I'm
Yes.
sorry, I just remembered it. I'm requesting return of his 2 phones and release of the car to the insurance company.
I don't
Yeah,
think
I
that
don't think
there's,
there's
this
any-
case having concluded, I don't believe there's any further need for those.
The state does not object to that request. I can put it specifically within the judgment if the court would like me to do so.
All right, that's fine. Understand that the outcome here leaves a lot of questions unanswered. I think Mr. Wrench eloquently pointed out that no result here is going to satisfy everyone or perhaps anyone. But that is the ruling of the court, and we do stand adjourned.
Thank you, Your Honor.